The law of contract, contractual remedies. A contract is an agreement or promise made between two or more parties that the courts will enforce. In some cases, the agreements and promises made in contract are not kept by a party or more parties. The law of remedies is concerned with the character and extent of relief. An individual who has brought a legal action is entitled to once the appropriate court procedure has been followed. The individual has established that he or she has a substantive right and that has been infringed by the defendant. At the end of the video, learners should be able to achieve the following learning outcomes. When a contract is breached, a series of remedies may become available, such as damages, specific performance, injunction, rescission, or quantum merit. The term damages signifies a sum of money awarded as compensation for injury caused by a breach of contract. The type of breach determines the extent of the damages is awarded. The primary purpose of damages in contract law is to place the injured party in a position that they would have been if had the contract been performed. There are two general categories of damages. One is compensatory damages. That consists of general damages or special damages. Second is punitive damages. General damages. General damage is the most common type of damages. It covers the loss directly and necessarily incurred by the breach of contract. For example, A delivered the wrong kind of flour to B. B insisted that A pick up the wrong flour and deliver the right one. A refused to pick up the flour and said it cannot supply the right ones because it was not in stock. B successfully sued for breach of contract. The general damages for this breach could include 1. Refund for any amount B had prepaid for the flours plus reimbursement for any expense B incurred in sending the flour back to A, plus 3. Payment for any increase in B's cost in buying the right flour, or its nearest equivalent from another seller. The second type of damages is special damages. Special damages, also called consequential damages, covers any loss incurred by the breach of contract because of special circumstances. These are actual losses caused by the breach, but not directly or immediately. In order to obtain damages for this type of loss, the innocent party must prove that the breaching party knew of the special circumstances or requirements when the contract was made. Let's say the same example of A and B. Let's say A knew that B really needed the flour for an event that will be held the next day. The damages for breach of contract could include all of the damages mentioned earlier, plus payment for B's expense in renting flours until A delivered the right flour. Third is punitive damage or exemplary damages. Punitive damages are intended to punish the wrongdoers for horrible behavior or deter others from acting similarly. However, punitive damages arise more often in tort cases to punish deliberate or reckless misconduct rather than contract. Section 74, subsection 1 provides the innocent party is entitled to receive compensation for any loss or damage caused by the party who has broken the contract. Section 74, subsection 1 also stated the loss or damages caused by naturally arise due to breach the parties knew when they made the contract to be likely result from the breach of it. The two principles that will be looked into in determining the award of damages are remoteness of damage and measure of damages. The innocent party may only recover damages for loss suffered due to breach of contract, provided that it is not too remote. The aim of damages is to put the innocent party in a position had the contract been correctly performed. This is clearly mentioned in Section 74, subsection 2 of the Contract Act. The principles are seen in the case Hadley v. Baxendale, which provides that only the following losses are recoverable. 1. All loss that flows naturally from the breach, and 2. All loss which was in the contemplation of the parties when the contract was made as a probable result of the breach. If the loss does not fall within the above categories, it will be too remote and not recoverable. The measure of damages is the method for calculating the damages to which the innocent party is entitled. The calculation of damages depends on the type of contract that was breached and the type of loss incurred. The general guidelines are standard measure, which is the amount that would allow the innocent party to buy a substitute for the benefit that would have received if the contract has been performed. For example, A contracts to buy B's ship for 60,000, but A breaks his promise. A must pay B the excess of the contract price over the price which B can obtain for the ship at the time of the breach of promise. And number 2 is contracts for sales of goods. The damages are measured by the difference between the contract price and the market price. For example, A contract to deliver 50 gantang of saltpeter to B on the 1st of January at a specific price. Now, before the 1st of January, B contracts to sell the saltpeter to C at a higher price. However, A breaks his promise. In estimating the compensation payable by A to B, the market price of the 1st of January and not the profit which have arisen to B from the sale to C is to be considered. Explanation of Section 74 imposes a duty upon the plaintiff to mitigate the loss or damage. It states, in estimating the loss or damage arising from breach which existed of remedying the inconvenience caused by non-performance of the contract must be taken into account. The plaintiff must take reasonable steps to mitigate the extent of damage caused by the breach. If it is caused by his or her own neglect, therefore, there is no compensation. The duty to mitigate losses can be seen in the case Kabatasan Timber Extraction Corporation versus Chong Fa Shing. Specific performance. Specific performance is a discretionary court order granted by the courts directing a person to carry out their obligations under the contract. It is applicable when monetary damages would be inadequate to compensate for the breach. Applications of specific performance need to be referred to the Specific Relief Act. The Specific Relief Act stated specific relief will not be awarded if the damages will provide an adequate remedy. 2. The terms of contract are uncertain. And 3. It will cause undue hardship to the defendant. The limitation of specific performance includes where the damages are adequate contracts that require constant supervision, where it will cause undue hardship and the parties have become incapable of performing, as per stated in the Specific Relief Act. Nuttbaum versus Taunton case shows specific performance is granted as it is difficult for the plaintiff to find a replacement, as the defendant was the only manufacturer for the type of machinery that is stated in the agreement. Injunction. Injunction is a court order to prohibit, threaten, or continuing illegal conduct of a certain kind. An injunction is classified under Part 3 of the Specific Relief Act, as we call preventive relief. Injunction is awarded in circumstances where damages would not be adequate remedy to compensate for the claimant. The claimant needs to restrain the defendant from starting or continuing a breach of negative contractual undertaking or needs to force performance of a positive contractual obligations. For an injunction to be awarded, listed are the criteria. 1. Plaintiff must have an interest to protect. Damages must be shown not to be an adequate remedy. And 3. There is danger that unless restrained, the defendant will breach the contract or continue with the breach complaint. For example, in the case Neo Siu Ng versus Tu Chi Kwang, the plaintiff applies for an injunction requiring the defendant to keep the water supply open. In the case Warner Brothers versus Nelson, the defendant had to return to the United States to continue making Warner Brothers film and complete the terms of a contract. Rescission. Rescission is the cancellation of a contract. The parties return to the position they would have had if the contract had not been made. Section 40 of the Contract Act stated, in the event of breach, the promisee may, unless he signifies by the words of conduct, put an end to the contract. However, the contract does not terminate automatically. It must exercise and communicate within reasonable time. The communication of rescission must be clear, and the option is revocable, and it must be total rescission, not in part. When a person at whose option a contract is voidable rescinds it, the party need not perform any promise, and the party rescinding must return any benefits gained through the contract. Refer to the case Mulyadhar Chatterjee versus International Film Corporation. Quantum Merit. Quantum merit is a claim for unspecified amount for service rendered. It is actually a doctrine by which the law infers a promise to pay reasonable amount for labor and materials furnished, even in the absence of specific legally enforceable agreement between the parties. In a simple term, quantum merit means as much as he has earned, or the amount deserved. Quantum merit can arise where there is an express or implied agreement to provide service, but no agreement as to the price. 2. Parties have not performed the terms of the contract, but a new contract has been inferred from their conduct to have replaced the original. A contract is terminated by breach after one party has performed his obligation. The party not in default may elect to accept the breach. And 4. Available to party who is prevented from completing his obligation by the other party. The application of this remedy can be seen in the case of Air Hitam Tin Dredging Malaysia Berhad versus YC Chin Enterprises Sdn Berhad.